Good afternoon. My name is Doug Cox, and on behalf of the Federalist Society, welcome to this special luncheon in honor of Judge Bork. We're delighted to have this opportunity to salute Judge Bork, who played such an important role in the life of the country and in the life of this society and of many of the individuals in the room. We're particularly happy that Mrs. Bork is with us today, along with the judge's family. I see there are many notables in the room and many alums of the judicial wars of the last century. I just want to single out Attorney General Tom Horne from Arizona, who's in town. He's going to be going in front of the Supreme Court next week, and of course, Senator Fred Thompson right here in the front. Senator. As Jean noted recently, Judge Bork was a truly kind and decent man who helped mentor a generation of conservative law professors and practitioners, including through his service as co-chairman of the Society's Board of Visitors. The judge also influenced our law and culture through his writing. The Antitrust Paradox was groundbreaking in its focus on efficiency and consumer welfare and remains the most cited antitrust book. In The Tempting of America, he places confirmation fight within the larger context of the ongoing struggle against judicial lawmaking. And his seminal article, Neutral Principles and Some First Amendment Problems, is credited by many with igniting the originalism debate. His last book, which we have a copy of right here, Saving Justice, Watergate, the Saturday Night Massacre, and Other Adventures of a Solicitor General, is blurbed by our own Leonard Leo. And Leonard writes, while certainly Judge Bork's confirmation struggle was an important political inflection point, what he did for the life of the law in this country and in defense of the Constitution greatly overshadows that one moment. Among the many facts of his personality, the judge's longtime love of martinis was a recurrent theme. He had a special martini recipe, and his clerks were notorious for becoming martini converts and for asking Washington bartenders for a Judge Bork martini, as the judge said, giving a slightly distorted view of life in chambers. The judge even wrote an extended analysis of how martinis properly deployed can fend off the pain of political defeat. That article appeared in the wake of Bill Clinton's re-election in 1996, when, as the judge observed, it was the election from hell. Our long national nightmare turned out to be only half over, and needless to say, it's advice that's still relevant today. When you reflect on Judge Bork's very American life, which stretched from his service in World War II through Watergate, the struggle over the Supreme Court, even on to the most recent presidential campaign, it is undeniable that his significance to the legal culture and to modern politics is vast. Perhaps no one can adequately sum up the career and legacy of Judge Bork, but few people are as well qualified to try as our guest today, Senator Mike Lee. We may recall that Senator Lee's father, Rex Lee, was Solicitor General under President Reagan, but he had early served as Assistant Attorney General in charge of the Civil Division at the same time Judge Bork was himself serving as Solicitor General. So the senator's connection to the judge goes back a long way. Senator Lee, I think it's important to note, was Tea Party before Tea Party was cool. He won his Senate seat in 2010 after knocking off a Republican incumbent and in a primary fight, and focused his campaign on the need to return to our founding constitutional principles. His devotion to the Constitution obviously has roots in his father's service in the Reagan administration. As he notes, growing up as the son of the Solicitor General, I may have been 30 before I realized that not every family discusses the Constitution's presentment clause over the mashed potatoes. He clerked for Justice Alito, first on the Third Circuit and then on the Supreme Court. He also served as an assistant U.S. attorney in Salt Lake and as counsel to Utah Governor John Huntsman. And of course, he is part of the legal generation that came of age under the intellectual influence of Judge Bork. In the Senate, he has been an outspoken defender of the Constitution. He has taken the lead on budget and spending issues, labeling deficits a barbaric practice. He has opposed the president's use of the recess appointment power when the Senate is in fact not in recess, to the point that the president singled him out for attack in a Saturday morning radio address, a badge of honor. His fearlessness goes beyond constitutional issues. For example, he asserted in debate that soccer was boring. Now, that's an obvious truism, but who among us would be prepared to risk the wrath of suburbia by such a bold statement? Along the way in his very busy life, he found time to write a book, The Freedom Agenda: Why a Balanced Budget Amendment is Necessary to Restore Constitutional Government. He's also been a good friend to the Society. In the wake of his election, he took the time to speak at the Society's annual convention. In those remarks, he said, "I will not vote for a single piece of legislation that I can't reconcile with the text and the original understanding of the U.S. Constitution," a conviction that Judge Bork would certainly applaud. Senator.
Thank you very much. It is true about the presentment clause discussions. It seemed perfectly normal to me that we should have those, but I'm sure the same happened in the Bork household. I was able to meet the third generation of Borks here today, and I thought I'd share a story with you at the outset of my remarks, a story from my own life when I was about the same age as Robert Bork III, and I am told he likes to go by Robert rather than Bob, thus distinguishing him from his father and grandfather, so there's no confusion. So when I was a teenager, when I was in high school, like many American teenagers, especially teenage boys, I had a slightly rebellious streak in me. And one day I decided that it was time to play hooky from school, at least for a couple of hours. School had gotten to be boring in that particular year, and it was in the winter months of 1988, I believe, that some friends and I decided that we needed to make a break from our high school. Like most American teenage boys, we wanted to do something kind of bad, kind of edgy, that our school teachers wouldn't necessarily approve of. And so we did what most teenage American boys would do at that moment. We broke away and we went to a local law school where we attended a Federalist Society event featuring none other than Judge Robert Bork. So that day really marked my introduction to two enduring institutions that have had a profound impact on me and on my approach to the law, the Federalist Society and Robert Bork. Even then, as a high school student, I recognized that the Federalist Society was the premier organization for lawyers who revere the Constitution and love America. And I sensed that Robert Bork was a towering figure in the history and the development of American law. These two were, of course, intertwined. Ever since the Federalist Society's inception in 1982, Bork was an active participant and friend to this organization. His ideas were an inspiration to our organization's members, and throughout his life he worked tirelessly to mentor young attorneys like me. I guess I'm not that young anymore, but sort of, committed to the cause. And it's therefore just such a great honor for me to have been invited to speak at this gathering of Federalist Society members and to comment on the life and the great legacy of Robert Bork, and to say a few words about the book that he completed just shortly before his death in December of last year. Robert Bork had what can only be described as a legendary career in the legal profession. He served as a tenured professor at Yale Law School, and I think that before and since then, the number of Republicans who served in that capacity can still be numbered only on one hand. He also served as United States Solicitor General, as acting U.S. Attorney General, and as a judge on the U.S. Court of Appeals for the DC Circuit. He served not only with great distinction in each and every one of these capacities, but also at very uniquely critical moments for our nation. And as a result, his name will forever be associated with certain pivotal moments in our history, such as those involving the Saturday Night Massacre, which we'll talk about here in a few minutes. And the drama of his nomination to serve on the U.S. Supreme Court and what happened to him within the United States Senate during that confirmation process led to the inclusion of his name, of the name Bork, in the Oxford Dictionary of the English Language. It's actually listed in there, and the definition of it is to denote efforts to defame or vilify a person, especially with the aim of making it difficult for him or her to hold public office. Not an exaggeration. That's where it ended up. I wish that those proceedings had ended differently than the inclusion of that name in that capacity. But Bork family, if it makes you feel any sense of consolation to have your name in the dictionary in that respect, my family name also has a definition. The Oxford English Dictionary defines lees as the insoluble matter that settles from a liquid, especially wine, sediment, the dregs. So I actually like Bork better, if that's any consolation. Some of my colleagues in the Senate probably do think of me as the dregs, especially after they've had a few glasses of wine. But the true legacy of Robert Bork stretches far beyond dictionary definitions, and also it stretches far beyond entry in books. His contribution and relevance lives on in the form of his ideas, ideas that live forever and will forever be regarded as having revolutionized the way we think about and respect the Constitution of our country. It's largely on the basis of his teaching that Robert Bork is often described as one of our nation's greatest legal minds and as a champion of the Constitution. So today, I'd like to highlight three of his watershed ideas that continue to define our profession and continue to have a positive impact on our great nation. No individual scholar has had a greater influence on antitrust law and policy than Robert Bork. With a series of articles published in the 1960s, he almost single-handedly laid the foundation for what became known as the Chicago Revolution, reorienting the world of antitrust toward protecting competition rather than simply protecting competitors. Indeed, the paradox of antitrust enforcement, according to Bork's seminal book, or if you're a feminist legal critic, Bork's ovular work, the most cited book on this very subject was that legal intervention artificially raised prices by protecting inefficient competitors from competition. Perversely, in other words, having exactly the opposite effect of what the antitrust laws were and still are supposed to do. Bork argued that the antitrust laws should be directed toward one fundamental objective, that involving allocative efficiency and consumer welfare. This standard of consumer welfare should be the lodestar, both because it involves rigorous economic analysis and also because any other goal would inevitably require the courts to make value choices and policy trade-offs, trade-offs that are properly left to the legislative branch. Bork's basic insight has revolutionized modern antitrust law. As a ranking Republican on the Senate Antitrust Subcommittee, I constantly look to the principles that he has defined. It goes without fail that whenever I work with my staff on this issue, when we're addressing one antitrust issue or another, either I or Rob or Bryson or another member of our staff would say, "What would Bork do?" And then we proceed to find the answer at that point. In each hearing, our principal arguments all revolve around consumer welfare, precisely because of Bork's great work in this area. And Bork's influence is not limited to free market conservatives like me. When he first published antitrust articles, all the way back in the 1960s, Bork's thesis was considered novel. But by the 1970s, it had become conventional wisdom in federal courts throughout the entire nation. And by the end of that decade, the Supreme Court explicitly adopted Bork's view of the Sherman Act as a consumer welfare prescription. In case after case, the court has endorsed his reasoning, rewriting the standards applicable to non-price vertical restraints, to maximum resale price maintenance, and to minimum resale price maintenance, almost always citing Bork's academic work with approval. It would be difficult to overstate Robert Bork's influence on antitrust law. He literally wrote the book on the subject, and others would follow his lead. After publication of his 1971 Indiana Law Journal article entitled Neutral Principles and Some First Amendment Problems, Bork also became widely known for his identification of Madisonian or counter-majoritarian dilemmas inherent in the American constitutional system. Our system contains two opposing principles that must continually be reconciled. First, self-government or majoritarianism, such that in wide areas of life, majorities are entitled to rule. And second, that there are nonetheless some things that majorities cannot do, that they may not do, they must not be permitted to do, such that coercion by the majority in these aspects of life is itself tyranny. The Constitution places in the non-political judiciary the responsibility to reconcile principles of majority power and minority freedom, creating the seeming anomaly of judicial supremacy in a democratic society. For Bork, the identification of this Madisonian principle, as he referred to it, yielded a foundational insight. Confining judiciary's power to its proper scope is absolutely essential to protecting liberty. He wrote, "The court's power is legitimate only if it has a valid theory derived from the Constitution of the respective spheres of majority and minority freedom. If lacking neutral principles, judges merely impose their own value choices. Courts violate the very basis of the Madisonian model that alone justifies their power, and they, in Bork's famous words, necessarily abet the tyranny either of the majority or of the minority." Bork's key insight about the role of judges became one of the Federalist Society's three-pillar tenets, three central pillars, that it is emphatically the province and the judiciary, and the duty of the judiciary to say what the law is, and not what the law should be. This view has become so widespread that it seems that every judicial nominee, and I mean every single judiciary nominee that comes through the Senate Judiciary Committee, now feels compelled to recite what we might fairly now call the confirmation liturgy, that judges must faithfully apply and interpret the Constitution, leaving aside, of course, their personal policy preferences, if only they would honor that commitment once they got onto the bench. A final element of Judge Bork's legacy can also be seen during the Senate's consideration of judicial nominees. You know, in her Senate confirmation proceedings before the Judiciary Committee, when she had been nominated to the Supreme Court and was being reviewed by the Senate, Elena Kagan went out of her way to stress that jurists should apply the Constitution's original meaning whenever feasible. "We are all originalists," she famously stated. She's not typically thought of as an originalist, but we welcome her at Federalist Society events nonetheless. The rise of originalism as the legitimate interpretive method owes much to Judge Bork. He was, in many respects, the originalist. He was originalist before it was cool to be an originalist. I was very impressed by the way that I was introduced as someone who was Tea Party before it was cool. I hadn't realized that it was cool yet. In his best-selling and perhaps most well-known and enduring work, The Tempting of America, Bork argued very forcefully and effectively that applying the Constitution according to principles intended by those who ratified the document was the only approach that was consonant with the design of the American Republic. Because no other method of constitutional adjudication can safely confine courts to a defined sphere of authority, originalism may well be considered a necessary inference from the very structure of government laid out in the constitutional document. Much might be said about Bork and about his dedication to originalism. Indeed, the Federalist Society has held entire conferences and published full-length books on that very subject. But for now, I'd like to read one passage from the Master, which remains as true today as it was decades ago when he wrote it. Quote, "The abandonment of original understanding in modern times means the transportation into the Constitution of the principles of a liberal culture that cannot achieve those results democratically. The interpretation of the Constitution, according to the original understanding, then, is the only method that can preserve the Constitution, the separation of powers, and the liberties of the people." An important part of Robert Bork's legacy are the countless law students, attorneys, judges, justices, and citizens across the country who march under the Originalist banner, seeking to defend constitutional government, and by defending constitutional government, also defending American government, our uniquely constitutional form of government. Judge Bork's final book, Saving Justice, is a worthy tribute to the integrity and to the spirit of this great man. It's also a fascinating read and one that I highly recommend. Bork made this book interesting in so many ways and for so many reasons, but one of the primary reasons is that he himself describes experiences that he had in light of the fact that he arrived in Washington to assume the position of Solicitor General at a particularly hectic and pivotal time for our country. The controversy that was to engulf the White House, not just involving Watergate, but also involving the prosecution of Vice President Spiro Agnew for his receipt of bribes while serving as governor of Maryland, brought with it some excruciating challenges for the Department of Justice that ultimately fell upon Robert Bork to have to deal with. Bork's very straightforward account of his wise response to these challenges is both entertaining and it's also a wonderful principled lesson in decision-making under fire, in decision-making when it really counts, and decision-making at times when all eyes are on the decision-maker. Throughout the book, we learn how Robert Bork's jurisprudence informed his life. Neutral principles, as it turned out, and as Robert Bork firmly believed, are essential not just for judges while sitting on the bench and deciding cases. They are also critical in all forms of public service. Bork's account reinforces through the experiences of his life and his experiences at the Department of Justice the high ideals of the law, and in particular, objectivity and due process. This is particularly true when it comes to his discussion of the Saturday Night Massacre, when the Attorney General and the Deputy Attorney General resigned rather than execute President Nixon's order that they fire Special Prosecutor Archibald Cox, leaving Bork in an extremely precarious, very difficult, unenviable position. Bork had two really difficult choices to make, two really awful options on the table. First, he had to decide whether or not to fire Cox, whether to fire Cox or instead to simply resign himself rather than do that. And secondly, he had to decide if he did, in fact, fire Cox, whether he, Robert Bork, should thereafter resign after firing Cox. At the time, Bork was the last man in succession to lead the Department of Justice. Had he resigned without firing Cox, a White House figure would likely, almost certainly, I believe, have been appointed to lead the department. And it would have, I believe, and he concluded, done considerable harm to the U.S. Department of Justice to have that happen. Once he realized that the argument against firing Cox was personal and none too credible, that it was fear about the consequences for himself that made him hesitate, the choice for Robert Bork was clear. He had to fire Cox. There was no other choice. The decision to remain required no less courage. Resigning would mean, of course, yet again, that in that circumstance as well, the White House would install a functionary caretaker of sorts, an official to lead the department from outside the department. Knowing that not resigning would limit his ability to deflect the anger and the apprehension of firing that firing would cause, he nonetheless took the necessary course and he stayed in office, and he did so for the good that he could do and for the sake of continuity within the department. But this was a selfless act and an act that reflected sound judgment on the part of Robert Bork, who, when faced with difficult decisions, allowed principle rather than passion to govern. Bork always trusted process, and he had a certain disdain for a preordained outcome. With respect to Watergate, he favored using the usual channels of communication and investigation, crediting the Washington, D.C. U.S. Attorney's Office with composing 90% of the case against Nixon, even long before the special prosecutor had ever been appointed. In fact, he noted with irony that it was the appointment of the special prosecutor that probably delayed Nixon's exit from office. If anything, Bork writes, the time spent appointing the special prosecutor and getting him up to speed only delayed Nixon's otherwise sealed fate. Among the disappointments Bork cites in the aftermath of the Saturday Night Massacre was the failure of so many lawyers to act like lawyers. Now, he meant lawyers in a good way there. Failure of lawyers to act in a lawyerly way, in the sense that they were doing their duty conscientiously. In his words, prone to complimenting each other as specialists in process, many lawyers demonstrated during the week after the massacre and throughout the entire Watergate affair how easy it is to let process take a back seat to preferred political results. Yet another reason why it was a shame that this man was not confirmed to the U.S. Supreme Court. A few other aspects of Bork's public service stood out to me. First, his professionalism and his raw talent. Notwithstanding the prodigious workload of the Office of Solicitor General, Bork upheld the long-standing tradition of personally reviewing every single pleading that was issued by the Solicitor General's office and filed with the Supreme Court. This meant about 6 pleadings a day, every single day, including Saturdays and Sundays. In fact, he adds, more often than not, I managed on top of that to do some crossword puzzles, a ritual that amused the staff. Bork's first argument before the U.S. Supreme Court came at a particularly difficult time for him while serving in this job. With events surrounding the prosecution of Vice President Agnew overwhelming his schedule, Bork had only 1 week to write 2 briefs in response to motions filed in that case, the case he was about to argue as his first before the Supreme Court. And he was left with only 1 single day to prepare for his first Supreme Court argument. I think this is a nightmare that every one of us as lawyers have had, and yet few of us have experienced this, and Robert Bork actually did. After barely meeting a Saturday night deadline for a brief in the Agnew case, he headed back to the office on a Sunday morning to read the key cases and the briefs again as if cramming for an exam. Bork writes, I don't advise heading into the Supreme Court, or any court for that matter, with 1 day's preparation, but I had no other choice. Nevertheless, he calmly concludes that notwithstanding the obstacles he faced, his first oral argument before the Supreme Court, for which he had had a sum total of 1 day's preparation, went smoothly. I was also struck by another aspect of Bork's animating principles, one that is perhaps sometimes lost even as we appreciate the magnitude of his influence on the law, but which this book brings forth. Bork understood the law so well, and he loved the law for its own sake. It was an end unto itself. During his fateful Senate Judiciary Committee confirmation hearing, one senator asked Bork why he wanted to be on the Supreme Court. His answer was telling. He first noted his love of the law and that he had spent his life in the intellectual pursuits of the law, and he would relish the opportunity to continue to do so on the Supreme Court. But it's his second answer that really illuminates Bork's most basic motivation. Whether approaching antitrust or framing constitutional jurisprudence, Bork sought to establish legal principles that would safeguard the American Republic as a whole. He answered, quote, "I would like to leave a reputation as a judge who understood constitutional governance and contributed his bit to maintain it. Our constitutional structure is the most important thing this nation has, and I would like to help maintain it and to be remembered for that," close quote. Today, in this great gathering of his friends, his former colleagues, his admirers, his teenage groupies, we most certainly remember Robert Bork as one who understood the treasure of our nation's constitutional structure and who was instrumental in helping to maintain it even through some of our very darkest days as a republic. I've touched on only just a few themes from this quite extraordinary and remarkable book, and I hope each of you will read it and enjoy it yourself. Judge Bork's career was, in fact, truly exceptional, and his storytelling ability is no less impressive than was his legal career. I'll leave it to you to enjoy some of Bork's best stories, including his first meeting with President Nixon, his artful refusal to resign as Solicitor General, his artful refusal to act as President Nixon's defense counsel, his work responding to Justice Douglas's bizarre order that our military stop bombing in Cambodia. That one's especially important. His impromptu meeting in the White House bathroom with Attorney General Richardson during the Agnew affair, and his work as acting Attorney General to provide critical continuity and preserve the rule of law. Each of these stories is accompanied by interesting asides and Bork's ever-present and dry wit. Let me close by quoting George Will, who in reviewing this very book aptly wrote, quote, "Bork deserves to be remembered by a grateful nation for the service he rendered in preventing disarray in the Justice Department and at a moment of unprecedented assault on the rule of law, and for facilitating the removal of a president during Washington days that were darker than most people can imagine." Close quote. Robert Bork was the very best, as a scholar and as a public servant. We're all fortunate that his legacy lives on, and it's been my privilege and an honor to celebrate his life today. Thank you very much. They've asked me if I'd answer a few questions that any of you might have, and as I always say when I'm doing a Q&A session, I'm happy to answer questions about anything you want to talk about: law, politics, fashion, relationship advice, or in this case, Judge Bork's jurisprudence. In that case, we'll call it a day. Thank you very much.
Senator, thank you for joining us today. Everyone, I think, benefited from your remarks. We do have a tradition in this chapter of giving our guests a leather-bound copy of the Federalist Papers. We're sure you don't need it, but perhaps you can slip this to Dianna Feinstein.